all about like, what if the Korean family is still here?
Oh,
Hey.
and we are now live. No, we're not talking about Korean families today, though. We could if you really want to know, but we are not that smart, so we don't. We might not have those answers for you. So, hi everyone, welcome to Legal Lunch and Learn, a weekly live show where we ask you, we ask an expert. Yes, we do ask you, Douglas, our expert. We ask an expert your questions on a legal topic. My name is Cindy. I am a staff attorney here at Maryland Legal Aid. My co-host is the Director of Community Lawyer Initiative, Megan McDermott.
Hey, Cindy.
Hello, our production engineer is Alex Chase, who's working in the background, making sure everything is running smoothly. Joining us today, and you have seen him before, is our housing law expert, Douglas Nivens.
Oh, good afternoon. How is everybody?
We are doing great. I'm doing great. I can't speak for everybody else, but I'm doing all right. I'm glad we have this very important topic today, which is an update on rent court, and we will be talking a little bit about the eviction moratoriums. So if you do have questions about either of those topics, you can direct message us. If you want to remain anonymous, you can put a question in the comment down below, and Alec will be the one to funnel those questions to us, so to make sure that we get those questions answered. But if you do have an immediate legal issue, and I do say this every time, make sure you're contacting us. And if you want to talk to a lawyer one-on-one about your specific issue, make sure you're contacting us. Our email here is lawyer@mdlab.org. That is LAWYER@mdlab.org. Our phone number here is 443-451-2805. For those who need captions, these videos will be uploaded onto YouTube. And last but not least, and I know I say this every time, but I think we have to say it every time, just because you take some legal advice from us and you like us as human beings, it does not establish an attorney-client privilege or relationship between you, any of the attorneys you see here, or with Maryland Legal Aid. So again, if you do want to talk to an attorney one-on-one, make sure that you're contacting us. So with that out of the way, I know I'm not ambushing you with this question, Douglas. Do you want to tell us something interesting about yourself?
Yeah, which explains why we're talking about Korean royal families and Korean dramas. That for a year during my junior year at university, went to University of Maryland, Baltimore County for political science, but I spent a year abroad in Seoul, South Korea at Yonsei University. So at that time, I knew a whole lot of Korean language and culture. I'm not as knowledgeable in Korean language as I used to, but it's still a cause near and dear to my heart. I still recognize the alphabet, and if you get me in a conversation, I might know half the things I say to you. The other half of things that it feels right, I know is there. My 21-year-old self would know what it was, but it may take me a moment.
Yeah, and it's really a shame that because of the pandemic, we can't really travel internationally or not as easily anymore. Mm-hmm. So, all right. So with that going on, sorry, this is a little bit longer intro. So with all that's going on and with the pandemic, let's go straight to our main questions. So right now, I believe all Maryland courts are in what's called phase 2. Mm-hmm. And I know you do still regularly go to court. So can you explain to us what does phase 2 mean?
In the landlord-tenant context, the modified phase 2 that we're in, which is going to go through March 14th. So presumably we may either be on it in March 15th or maybe in a different phase in March 15th. We don't quite know, but at least through that time, the court is hearing what it considers emergency tenant holding over, emergency wrongful detainer, and emergency breach of lease cases, as well as rent escrow hearings, regardless if it's emergency or not, so long as the inspectors are able to visit the properties in Baltimore City. Rent escrow hearings are held going forward. When it comes to other jurisdictions, again, it depends upon whether or not the court and the inspectors who may be with that court can perform that operation to do rent escrow. So those are the main category of landlord-tenant cases at the initial trial level. When it comes to fair to pay rent and non-emergency tenant hold over, breach of leases, wrongful detainers, those are not being heard right now. We know that may change come March 15th, but at least right now, they're not happening.
All right. Can people still file? Can landlords still file a failure to pay rent even though no hearing's been granted right now?
Yes. So the courts will set filings in all cases. It's just a matter of whether or not they're going to schedule them for a date. And for those cases that at least between mid-February through March that was originally scheduled, they're going to be rescheduled to some later date. Now, I understand there are certain circumstances. I know for some of my clients, we are able to look on the court's judiciary website, the Maryland case search, and we can see whether or not a case has been scrapped or not. Some people are getting notices saying that there's no hearing. Some people are not, and that's because we're all being affected in the greater Baltimore metro area with delays in mailings. The court is already assuming a 3-week delay when it comes to notices. So I will recommend for anybody who is inquiring, do I still have a court date? Contact the courthouse, as well as if you have access, go to Maryland Case Search. And I would recommend just typing out Maryland Case Search to bring up the web address, probably the easiest way to find it. Put in your name or case number, and you can find whether or not in your particular case there still is a hearing.
Yep. Well, except for I think failure to pay rent in some counties, they're not on there.
In that case, you should contact the courthouse directly.
Yep. I think it's always a good idea if you're not sure or if you don't remember, what's the website I go to, just give them a call. I think clerks are much happier for, to just tell you what's going on than having to sort of all the stuff that goes wrong if, they don't answer your question.
Yeah. As a former clerk, I'll tell you, always ask.
Oh, I didn't know that. More interesting facts about you.
It is my, I don't know, it's a blessing or burden in life that I'm always attached to rent court. But yes, that was my very, very first job out of UMBC, was a court clerk.
Oh, wow. That must give you a very, different perspective from other attorneys in terms of, just filing, how the court functions.
Mm-hmm. Yeah. I've had an interesting career. Yes.
So with that said, let's go down towards the nitty gritties right now. So you said earlier that, emergency hearings are still taking place for tenants holding over.
Yes.
And what's the other?
Wrongful detainers, breach of leases.
Yep. So can you explain what so first of all, what those things are, and two, what is considered emergency in those cases?
Okay. From what we've heard from the courts, what is considered an emergency tenant holding over or wrongful detainer will depend upon whatever notice is attached to the complaint that indicates it is an emergency. That determination is being assessed by the judges as they review complaints to see does it qualify or not. There's no definition in the statute of an emergency tenant holding over a wrongful detainer. So the courts are just looking to see if there's anything there with that filing. Breach of leases, there are provisions that define what is an emergency or not. When the landlord files that complaint, there's a box that the landlord can check off to say it's an emergency. For breach of lease context, an emergency breach of lease usually comes with a 14-day notice to vacate preceding the filing. So that's one obvious indicator. But the courts are also going to look to see in the notice of a breach of lease, does the allegation rise to an emergency, which in a very plain way to define would be a threat to life, health, or safety of the occupant or the premises. So if somebody, for example, is alleged to have willfully damaged the property and there's a potential that there be further damage, a court may think that it's an emergency or just any threat to a person's life.
So if someone is granted an emergency hearing, and of course we at Maryland Legal Aid, so for those viewers out there, Maryland Legal Aid only represents tenants. We do not represent landlords. So if there is an emergency hearing in terms of tenants, how long do they have to, get all of their evidence together and get ready for a hearing? About how long are these hearings being set out?
In Baltimore City, we are learning from the courts that they are assuming a 3-week period to send out notices. So they are assuming that whatever date is sent out, hoping 3 weeks you'll know it, and then a week or two thereafter you'll have your hearing. So it'll be a little bit of lead time, ideally. However, if the court wants to have a hearing sooner, then the ordinary process is for the clerks to contact the parties to see if they are available for a certain date. Now, in Baltimore City in particular, those hearings are still being held in person. However, any party may request that hearing to be held virtually.
How do they do that?
One way is that any party may file a motion, and in the district court, there are forms available. They can fill in the blanks, but there are also other forms that have been recently designed to allow a person to indicate to the court, I would like a remote hearing with their reasons why. So those forms are available online. If you go to mdcourts.gov under court forms, one may be able to find that information, or again, contact the courthouse to see what steps that court wants you to take to have a remote hearing or to have a sooner hearing. And just as how somebody may ask for this, a party may also voice their opposition. So they may say, no, I want to have an in-person hearing. I want to see my landlord in person, the evidence and the witnesses. They may also raise their objections.
Yep. So with all these hearings still happening, with all these cases still being able to be filed, can people be evicted right now?
Yes. Yes, they can. It depends upon the reason of the eviction. Mm-hmm. So if there's any warrant of restitution for judgment before this phase, so any judgment that happened, let's say in September, October, or even early November, so long as the landlord files that warrant of restitution and that warrant of restitution is valid, the sheriff will conduct an eviction on it. That goes.
Sorry, I want to back up for those. So first of all, we get new audiences all the time, and I don't know if they necessarily watched our last video where we explain warrants of restitution is. Okay. So really briefly, what is it, and how would a landlord get it? Because it's not like a landlord can just go to court, get it, and then,
Yes.
Yeah.
So let me just back a little. For first, a landlord will have to file what we call a complaint that alleges why they want to retake the property, according to what statute, if it's fair to pay rent, tenant over, or breach of lease, what have you. There will be a hearing where the court will determine whether or not to grant that, grant a judgment. So in this scenario, let's say that the court sides with the landlord and awards possession of that property to the landlord. So they get judgment. Thereafter, at a certain period of time, whatever that appeal period is run, so it can be 4 days or 10 days, what have you, the landlord has to go back to court and file what is called a warrant of restitution. It's like an application. Say, hey, the court sided with me. The tenant's still there. They haven't either paid their rent or they haven't left as was ordered by the court. I would like the sheriff to now move these people out of my property. And so that warrant, as we call it, is filed with the clerk's office. A judge will have to sign off on it, saying that everything is true and yes, you have a legal right to do this. That warrant then is transmitted to the sheriff's office. A copy of that warrant will be mailed off to the tenant, as well as another copy to be held at the courthouse, and then the sheriff will have the original copy, the stamped copy. That gives the sheriff the legal authority to go to a person's home and remove them, or forcibly, if necessary, to take them out the property, to actually do the eviction. Now, so under the rules currently, if I may add, there's supposed to be, the rules supposed to be for, the rules authorize the court to sign off on warrants of restitution on a case-by-case basis, but in Baltimore City in general, so long as the judgment is valid, many judges are signed off on the warrants. So that's why, yes, you can still be evicted now.
Yep. So that brings me to the next question. I think everyone wants to know this. And So keeping in mind that I know we talked about the CDC moratorium on eviction
Yeah.
last time, but I know a lot of people don't know anything about it, and it's not what people might think. It's not just, no one
Mhm.
signs warrant restitution, no sheriff goes anywhere. So can you explain how the CDC moratorium on eviction works, and maybe speculate about, when is it going to end? Is it actually going to end? Hopefully some executive orders will come out
Mhm.
asking the CDC to extend it.
So the CDC Fiction Moratorium is one of the two main ways we have a fiction moratorium that happens in Maryland. The other one is the governor's order, which we can talk about later. But for the CDC in particular, it is there's a few steps to it. First is that the tenant has to complete a declaration, like an affidavit, where they swear or affirm that the tenant is suffering from a substantial loss of income, that they are of a limited means, that the tenant is doing everything possible to get money to pay rent, but is having trouble doing so. But if they can, they will pay their rent. And because of the imminent danger to their life of being removed, meaning they may have to go to a shelter, they have to live with other people, or just homelessness, they're asking the landlord or they're notifying the landlord that they cannot fulfill their obligation, at least for rent payment. Therefore, they should not remove them from the property. Once that declaration is signed off and given to the landlord, it should provide a defense for a tenant to not be evicted, at least for failure to pay rent. We don't know how it is in other situations, whether the tenant will breach lease. That's still an ongoing process, to say you will. But that's one part of the puzzle. The next part is the landlord still can file for a complaint. They can still file for the case to remove the person, and a judgment may be entered against the tenant, especially in a failure to pay rent context. However, at least until the CDC declaration expires, the sheriff cannot, the court cannot issue the warrant which will authorize the eviction. So it's everything up until that warrant restitution stage.
So
Now-
that it sounds like the tenant does have to do something, actively do something, like, which is, fill out the form. I
Mhm.
will try to get a link of that in the video, because it is available online. So you do have to fill it out, and you say and then they have to give it to the landlord as well.
Yes, they
Okay.
have to give it to the landlord, and also keep a copy for themselves, because the
Yep.
tenant, if and this is for all tenants, if you're being summoned to court, you should go to court to be your voice, because the landlord may not tell the court, hey, I got the CDC declaration. The court won't know if you're not there to say it. So tenants, if they're in the court, could say, hey, I felt the CDC declaration. I want to assert it, saying, I don't want to be evicted. And the court, in prior practice, what they would do is they would issue the judgment, or they'll find in favor of the landlord, but they would not issue the actual judgment. They wouldn't sign off on it until after the end of the CDC declaration, which at this point, as of January 20th, is due March 31st, 2021. That may change. Like I said, we're in a new administration. New rules are coming out every day. So it may be extended.
Yep.
It's-
Yep. So again, for viewers out there, this moratorium is so specific. If you do have a question about it and you want to talk to attorney one-on-one to see if you qualify or what you should do next, please give us a call or email. We're very friendly. So that's the federal level, right? And
Yes.
I think there was a governor's order that came out, I think at the beginning of the pandemic, and I think
Yes.
the what you said was like, until the state of emergency is over. So what does that one do?
The governor's executive order provides tenants a defense, an affirmative defense, where again, they're saying that I have suffered from a substantial loss of income due to the pandemic. It could be a loss of a job, reduction in work hours. It could be, You have to spend more time or the care of a child who's in school because they're in school remotely, and that has affected your income. Whatever it may be, you're suffering from a loss of income, substantial loss of income due to the pandemic. You will have to have some objective proof showing that. So an unemployment application, a letter from your job that says, hey, you lost income, or even just showing your pay stub, say, hey, this is what I used to make pre-COVID, and this is what I now make. Some proof that shows why that you're losing income. And then the tenant may assert that defense in a failure to parent context, as well as in a breach of lease context, especially if the breach of lease is you're having people stay here in your premises during the pandemic, and that's explicitly is protected because we want people to stay home. So in that context, again, the court may they may find in favor of the landlord, but they cannot sign off on that judgment. They have to, we call reserve judgment. They're holding it in their hands, and therefore, since they haven't released the judgment, the landlord can't file for the eviction. Now, again, that doesn't expire. That's supposed to be until the governor declares the pandemic over.
Yep. So that brings up another question in terms of, what if you do go to court and the judge finds against you because, after all, you weren't able to pay rent. So what happens after the pandemic's over? Do you just, once you find a place to move and that's the end of it? Or are there any repercussions, like financial or otherwise?
In terms of, so we're saying if you're in a situation where the pandemic is over and the court releases judgment, what's next? So in that situation, then the landlord would be able to get a warrant of restitution and begin the process of scheduling an eviction. We don't know how long that may be. Even pre-COVID, at least in Baltimore City, it took about 6 weeks before people got on the eviction calendar with the sheriff's office. And in Baltimore City, at least for failure to pay rent cases, tenants are due a 2-week notice of that date. And one thing I will say, if it's in a failure to pay rent context and tenant has made some payments of rent, I will also advise tenants to advise the court of that. Say, hey, what's on the complaint that says I owe? It's a different balance. Here's my receipts. I've been making payments. This is what I truly owe. That way, when the court issued judgment, it's the most current amount that is actually due and owing, not what it was back in the initial trial, whenever that was.
Right. Absolutely. So I think that's all I have in terms of main questions. Really, it's I know it's shorter than last time because it's really mostly update. And again, viewers, if you're interested in a more a little bit longer explanation of the legal process and all the questions about what's going on in court right now, you can go ahead and watch our previous video as well. So with that said, I'm going to go ahead and turn to Megan for our questions from the audience.
Thanks, Cindy. Hey, Douglas. Look, I know a lot more about you after this.
Don't worry. We share a tidbit together too. We're both alum from the federal government.
Oh, that's true. That's right. From the same agency, correct?
Yes, we are survivors.
We are. You can message us privately if you want to know what agency. Okay, we got a couple logistical questions in. Someone wanted to know if the information that you've shared so far is applicable outside Baltimore City.
So for the CDC and the government moratorium, that is the same, as well as in terms of what cases can be heard, that is governed by the Court of Appeals administrative order. So all of that affects all courts in the state. What may be different is how each courthouse, their process, they determine what is an emergency or not. Now, we all think that emergency should be life, health, and safety, those type of threats. But at the end of the day, it comes to the individual judge who's reviewing those complaints to see, is this an emergency or not? So you can have variability, not just within locales, but just chamber to chamber, but what constitutes an emergency. Now, I do know that rent escrow processes are different. Some jurisdictions don't have a court inspector visit a property. Some places do, like in Baltimore City. So in those circumstances, I would still inquire with the courthouse to see, are they still doing rent escrow hearings during this time? And if so, by all means, if you feel as though you qualify, you may check over the process how to do that. Again, we also assist with representing in rent escrow matters. But like I said, if there are other questions, particularly about what is my courthouse is doing, feel free to contact the courthouse, or you also contact your local Maryland legal aid to see if our attorneys have more insight on that.
Okay. We actually got 2 questions about tenant holding over as well. Just asking if you could explain what it means. And also, and I think this probably goes to what you were just saying, whether or not that's considered an emergency matter.
Great. It is an ongoing debate about what is an emergency tenant holding over. So by definition, a tenant holding over means that there was some lease or tenancy that the landlord tenant agreed would be the term. So it could be a month to month or year to year. It could be 1 year that turns into a month to month. Whatever it is, there's some term, and that term has come to an end. In many places, the landlord has to give some sort of notice, either it's 30 days or in Baltimore State, it has to be 60 days notice of when that term ends. So if it's a year from January to December and you're in Baltimore City, then that tenant needs to receive notice before November that their term is about to end for the landlord. At the notice, the tenant, let's say, lease ends December 31st, the tenant's still there on January 1, then the landlord may go to court and say, hey, the tenant has held over, I mean, they stayed over the time they're supposed to leave, and ask the court to evict that tenant. Now, that does not necessarily give rise to what's the emergency. You just stayed over or held over. And that is the debate that we are having as advocates over what does it mean to have an emergency tenant over. What we've learned from the courts is that the courts are going to look at what the notice says. So when a landlord files their complaint, they have to attach that notice that they gave the tenant ample opportunity to leave. If that notice has something that would give rise to an emergency situation, then the court may schedule that hearing during this period. Again, that is an issue that the tenant can object to. The tenant can say, look, this is an emergency situation. We don't need to have a hearing right now. And I would suggest if that's your situation, you should contact legal representation to help make that argument.
So it sounds like the emergency situations can be fairly subjective.
Yes.
Okay.
Yes. It's an ongoing debate that we as advocates are having with the landlords community and with the court over what this really means. So far, I have not had a emergency tenant holding over, and the breach of lease cases, which I was a part of, was canceled because the landlord didn't allege an emergency situation. So thankfully, we've been so far fortunate, but I do understand that they are happening in the courthouse.
Okay. And then another question. So to deal with sort of, I guess, the proof that you have been affected by the pandemic, this person is asking, how does the judge know if the household income was affected by the pandemic? I guess what kinds of proof should you have with you if you are going to trial?
I would recommend any documented proof. So it would be if one lost a job and they apply for unemployment, any copies that show that you filed for unemployment during this period of time because your workplace is affected by the pandemic. Any type of loss of wages. So if you could show any letter or document from your employer that says, I'm letting you go because of COVID, or I would say, if you haven't got one and you have still in communication with your former employer to ask for that documentation. Or bring proof of your wages and show, hey, this is what I used to earn. This is what I now earn. If you're in a situation where your loss of income is due because you have a child who you have to now watch because of school, I would bring proof that where your child is enrolled, what their virtual schedule is like, and showing how because of this schedule that you now to be home to watch your child has shown or affected your hours. I would say whatever you have available to tell your story, I would say to have it, especially if you can print it out or have a paper form. I understand many people use their cell phones, and that's fine. That's an understandable means, and many courts will look at your phone. But I'd also ideally caution against it, because I think one should always be cautious of handing something that's so personal and intimate to a judge. So I would say if you could print it out, you have some way to print it out, do so. Keep your phone obviously as backup, but it's good to have hard copies.
Definitely, that's great advice. Okay, so people are asking a lot of questions about sort of, and I know you can't, you're very smart, but I don't know that you can see the future.
Oh, if I could see the future, I would have a very different, probably really well-paid job. Write my own salary. But anyway.
So what about looking to the future, though? Once the moratoriums are lifted, I know this is a question that people have. What happens as far as back payment? People are asking sort of questions like, do I still have to pay rent right now? And once a moratorium is lifted, what do I do if I owe, I haven't worked for a year? Can my landlord still come after me then? And I know maybe some of those questions, there might not be a solid answer right now, but what would you say to those folks?
I think the one thing we need to dispel is there's a belief that many people have caught on that because courts aren't hearing, say, rent cases, I don't have to pay rent. No, your legal obligation to pay rent is still ongoing. In many places throughout the state, at the local level or the county level, there are certain places that may have a freeze on rent increases or a freeze or limit or prohibition on late fees. That makes sense. But the duty to pay rent is still there. And so even once the moratorium are over, because thankfully one day we will emerge from this pandemic, the tenant is still liable for that rent. So the best thing I would argue is at this point is document your effort to pay your rent, to have your receipts. For many people that may be different money orders, so I'll say make sure you have copies of that money order, get a receipt from your landlord, or make your own receipt that the landlord signs off showing that you have made payment. Apply for any eviction prevention assistance. In Baltimore City, the Mayor's Office of Children and Family Success, also part of the CAP centers, are still awarding or still issuing out eviction prevention payments for several months. Also, Department of Social Services have eviction prevention funds. So I would say apply for that funding to help reduce the amount of rental debt one may have. And again, keep track of what you truly owe. I see very many situations where tenants rely on the landlord's ledger or landlord's notes over how much they truly owe, when in fact, really, you should know what is going on in your own personal finances. And if you haven't already, create your own trail of what you truly owe, what you've paid, so that when there is a dispute about how much it is, you can offer, oh, no, this is how I truly owe. This is how I calculated it. We don't know, again, if there's going to be any other financial relief coming from the federal and state government. That's ongoing at both the new Congress and the new General Assembly session. But for now, I would just say, if there's a legal right to pay what you can, and document that effort.
So rental assistance is currently it's sort of by county, right? There's no state or government sort of rental assistance for folks right now. Okay.
Yeah, it's been a lot of money came from the federal government, it filtered to the state, and now the state filtered down to the localities.
Okay, so people should check with their local governments whether there's a waiting list or if they can apply for it now and how many months and things like that.
Yes.
Okay. And then if someone, as far as sort of proof of payment, if you ask your landlord for a receipt, do they have to give you one?
Well, under state law, if you pay in cash, you are owed a receipt.
Okay.
And it is an ongoing duty of the landlord to maintain a ledger. Now, I understand for many people, they have a very casual relationship with their landlord, so they may not always have receipts, and many people have their money order receipt. But I remind people, your money order receipt shows that you pay for a money order. Doesn't necessarily mean that you paid your landlord. So if your landlord doesn't issue a receipt regularly, there's nothing wrong with you creating your own receipt so long as the landlord signs off and says, hey, yes, I received payment. And that's a way as proof to you that there was this transaction. Because, I would say people don't call a lawyer for a good time. They usually call us because something bad happens. And so when times are good, understandably, hey, why rock the boat? But I would say there's nothing wrong, trust but verify. This is your way to verify that this has happened. It really protects everybody because everybody can have common facts to rely on when determining how much is due and owing.
Okay. So people are also asking on Facebook, it seems like it might be common for landlords to send people a letter saying that, hey, your lease is terminated and you need to move out by, February 1st or something like that. And I know you talked a little bit with Cindy about warrants of restitution, and it sounds like a landlord can't just send you a letter saying you're evicted. But what could that letter be, and what would it mean, and what should people prepare for if they are receiving a letter like that?
So I'm gonna split this up in two different categories for those who get subsidized rent and those who are not. So in those in the subsidized rent realm, there are federal rules in place that says that the landlord has to give you 14-day or 30-day notice that they're going to file a rent action against you because you failed to pay rent. And that's rules that they have to abide by. And in those situations, they may say, hey, I'm going to file. And again, the courts are accepting filings in rent cases, but they're not scheduling them. I know different localities have different calendars. I know in Baltimore City, new rent hearings are now being scheduled in July and August. So they may have to do it, but you may not have a hearing for a really, really long time. In the private landlord sector, if they're going to file a notice to terminate your lease, it has to be a proper notice. So in a tenant holdover situation, if you're in a month-to-month lease in Baltimore City, you got to get 60 days. Most other places in the city, in the county, most other places in the state is 30 days. So they have to give you that notice to let you know. But all that means is your lease is going to end, and then they may take steps to file against you. It doesn't mean that, oh my God, come February 2nd, the sheriff's at my door. No, not at all. The landlord still got to go to court and convince a judge to award them possession. And even after that, they still got to file for a warrant and still got to schedule with a sheriff. Only a sheriff, for order of the court, can evict a tenant. Self-help evictions is illegal in Maryland. And if a landlord try to do a self-help eviction, say they try to bolt your door, change your locks, cut off your utilities, all in an effort to get you to leave without the court involvement, well, that's a crime. And you can call the police to report it, as well as go to the court commissioner office to swear out a complaint for their wrongful actions.
Hopefully that gives people a little bit peace of mind that there's a process. You can't just get a letter and be told you have to get out next month.
Nothing ever moves fast. Not in Maryland, not in Baltimore City. So if you think this is way too efficient, chances are you're right. Something's wrong, and you should call legal counsel. That's what we're here for.
Okay, great. Now, what about folks who suspect an eviction is coming. You know, they've gotten a letter from their landlord. They've gotten their paperwork from the court. Obviously, hopefully they can present a defense if they have one. But the person saying, I don't have any money to move right now. So I know I have to go, but I haven't worked for a year or whatever. What should they do?
It depends. So if it's a rent case, so let's say it's a judgment, you went to rent court back in September and they finally went around and filed a warrant restitution, and it's all about rent money, then one option is to still go through the steps for the CDC declaration. Give the declaration, sign and give the declaration form to the landlord, and one may file a motion with the court to stay the eviction because you're saying, hey, this is about rent. I gave my declaration. I can't pay the rent. I'm asking the court to stay that eviction because this would apply in the CDC declaration, and bring the issue to the court to decide whether or not to go forward with it. It's better to do it early. There are times where one may bring this issue up on the day of eviction. Risky, but it can happen. Ordinarily, if there's a dispute about whether or not an eviction can go forward, the sheriff usually will order all parties to go to the courthouse so that the judge in that afternoon docket will decide then and there, can we still do this? But that would take steps for the tenant to give the declaration, to have that proof available, and make that one less effort to preserve their housing. If you're in some other reason, so it's a tenant holder over, a breach of lease, or wrongful retainer, that may not work. And that's because Maryland courts so far are interpreting the CDC eviction moratoriums only in rent court. Like I said, it's an ongoing debate. We're all having discussions about it and trying to see if by order, if the CDC itself will expand it, or if the courts may reconsider their position. But if you're at that situation where it's not about rent, like a breach of lease technically is not about rent, it's about you doing something else. You may not have your defense is limited. And at that point, you may have to consider saving your money and finding alternative housing or a place to move your possessions into storage. You, by all means, I would still say you can contact legal aid or to contact legal representation to see if there's some other defense available, making sure that did the landlord do the right steps to get that warrant of restitution. But if last ditch effort, there's nothing else to do, then I would say by all means, save your money, find alternative housing, find a place to store your possessions, because outside of the rent context, you may not have any notice of when the sheriff arrives once that warrant is issued. And every place in the state is a little different about how quickly they can do evictions.
Well, it sounds like if you think if it's coming, it's worth talking to us or to another attorney just to see if there might be any final kind of defense. Yes.
Again, we don't, we don't charge the public for our services. We for those who qualify, our representation, our advice is free. As I tell my clients, somebody else pay me. You don't, because We're here to help serve these communities.
Okay. A couple more questions. I think this is just a hot topic because people are really concerned. So the person didn't use the word retaliatory, but this is what it sounds like to me. If a landlord is doing something retaliatory where the tenant hasn't paid their rent and the landlord has cut off their utilities or won't fix something in the house that needs to be fixed, but the tenant says, I can't pay. Is that when you would do rent escrow, or is there something else a tenant can do to address that?
So there's a couple things. It is a crime for a landlord to shut off a tenant's utilities, your gas, your electric, and water, when it's the landlord's responsibility to offer those utilities. And there's no other reason other than they want you out, that's a crime. That's willful diminution of essential services. And that's a crime for which I will recommend a tenant may call the police to report it. They may contact, I know in Baltimore City, the housing department does inspection. So call 311 to get an inspector to document the lack of utilities and to swear out a criminal complaint in the district court commissioner's office. Because even if you don't pay rent, you have a right to live in a safe, habitable place. That is not how you evict a person. That's almost a constructive eviction, quite frankly. So you have every right to assert a crime and let the state's attorney process it so as they choose. When it comes to a landlord who fails to maintain the property as a way to induce the tenant to leave on their own accord, and we see this a lot right now, quite frankly, rent escrow is an option. However, rent escrow has its risks. Part of the rent escrow process is that a tenant must be current in their rent to fully utilize it. So if you have a tenant who is behind in rent due to the pandemic, but there are also significant conditions that rise to a threat to life, health, and safety. So there's real problems here. A tenant may use rent escrow, but the tenant will also have to make the court aware that there are other that they have a substantial loss of income, but maybe either due way of the conditions or in consideration of the governor's executive order or the CDC declaration, they can't pay rent, or maybe they shouldn't pay rent. And so that's an argument that one will have to make with the court. And I had a case like this last week. Different judges will react differently. Some may say, well, due to these conditions here, heck, I think rent should be zero because the value of this property is zero. Why would a person willingly pay rent in a place that has no electricity? Good point. But a court may also order the tenant to pay into escrow. So there's no hard and fast rule. It really will depend upon the court and on an escrow action on what to do in that situation. I would still say, if your jurisdiction has property maintenance inspections, like in Baltimore City, contact them to have an inspector to document the problems. And again, also for the tenant to also write a letter to the landlord saying, hey, these are the issues in my problem. I know I can't pay rent. Hey, you can even attach the CDC declaration with that letter, but document what is going on. Send it first class mail as well as certified mail, return receipt requested to be your document proof that, look, I gave my landlord notice of what's going on. This is how they're treating me. And then that could be a case for rent escrow or some other action. And again, I would recommend contacting a lawyer to help talk about what steps to do in your particular case, because it is a little nuance about how you go about using a legal process to represent, because all these laws were made in a time where we didn't have a pandemic. And the judges, as well as advocates, we're trying to work our way to figure out how to preserve people's housing while acknowledging that there are landlords who desperately need rent. But I would say that need for rent doesn't trump your right to safe, habitable housing.
That's a great point. Just thinking about how the laws were not made for this crisis, right?
No, not at all. Not at all. And we're all trying to figure it out.
Right. So speaking of inspections, that's a good segue. Someone was asking about a residence that is in abatement because of failed inspections. Can the landlord / owner of the property evict the tenant? Is there anything special with that, or is it the same eviction process that you would expect otherwise?
So we say this is a place where if you're in a place that has conditions, and you said there's an abatement of rent due to conditions.
It just says the residence is in abatement. There's no more
Okay, so
specificity.
I'm gonna split this up again between subsidized housing and private housing. So if a tenant is, say, in the Section 8 program, Section 8 program has their own inspectors. And in that process or in that program, if the inspectors on 2 occasions find that the landlord has failed it for some reason, and it's the landlord's fault why they failed inspection, then the Section 8 program may stop paying them rent. But that doesn't mean that the tenant got to stop paying rent. The tenant, you'd have to go to rent escrow to stop paying their share of the rent due to conditions. That's one way that happens. And the tenant still has a tenancy there. They still live there because the landlord made the opportunity to rehabilitate, fix it up. That's the goal. Now, one possible avenue in a rent escrow situation is that the law allows the court to terminate a lease. So you could have a situation where either by the landlord's suggestion or the tenant's suggestion to say, hey, due to the conditions, I don't want to live here, or I don't want to offer this place to rent anymore, and I want to end the lease. And the court has the authority to do that. But that depends upon the circumstances you're living in. And I would not suggest that for a tenant unless the tenant already knows where they want to go to next. And they're just, look, I found a new place to live. I just need to end this lease. Rent escrow may be that way to do that. But there's also a risk where a court could say, look, due to this condition, it is so severe, I don't think in good conscience I can have you still living there. So I'm going to terminate the lease on this date so that you have to leave. That's in their power. So to kind of mitigate that consequences, I would suggest definitely talk to legal counsel, because there may be a way in which we can form that argument that best preserve your housing without having to lose it. But that's also why I would say rent escrow is risky, because if the conditions are severe enough, either the landlord or the tenant could ask, well, the landlord could ask to terminate the lease, and you might have a judge that agrees. I would say in general, just because the condition doesn't mean your lease automatically ends. I wouldn't say that. I would say it still takes an order of a court to terminate your lease prematurely.
That seems to be one of the big takeaways here. Like,
yes,
there needs to be some kind of court involvement for all of these things. Don't just take your landlord's word for it.
No, you should not. Your landlord's going to guard your landlord's interests. You should. Your best advocate. You look at yourself, or those who like attorneys who, we're bound to be your fiduciaries. So I think definitely think carefully who you take your legal advice from.
I'm gonna do one more question. It's because we're kind of approaching an hour here, and everyone is busy. We want to be respectful of everybody's time. I just wanted to say, and I'm sure Cindy will say this when she comes back on, that if you don't answer your question, you can reach out to us for one-on-one consultation, or we will answer it during another program, of course, as well. But this question, again, this is sort of not necessarily a COVID question, but this person, a new management company took over sort of running the property where they have their lease, and they were not given notice that there was going to be new management, and all of a sudden they received a notice they were going to be evicted. So is there any duty around landlords or management companies notifying that there'll be new management, and then does the new management have to respect the old lease?
So if I'll give you a whole bunch of old property law, I would say your lease or your leasehold interest, it stays with you. So just because owners may change or the property management may change, you still have a lease, you still have a tenancy, and that will continue on under those terms of whoever may change. That interest that stays with you. So if the landlord changes management and it automatically issue a notice to vacate, one, it depends upon, going back before, is this the appropriate notice? Are they saying that they're giving you a 30, if you have a new management company, we see this with a lot of foreign property management company, out of state property management company, they say, well, I'm gonna give you 30-day notice to vacate. Well, that's not Baltimore City law. So we go back to the basics. Is the notice proper? Is this new management company, do they even have a legal right to operate here? Are they even licensed by the city? We go through the same basic questions when evaluating whether or not this is a valid notice. So I would say, by all means, simply changing of owners or simply changing of property management company doesn't mean that your lease automatically evaporates. Things get a little trickier when it's a bankruptcy situation. So I would suggest contact a lawyer if due to bankruptcy there's a change in ownership. But if it's just merely new property management, no, your lease is still the same here. And they have to abide by the same statutory rules. Your lease can't alter your notice requirements that the law already set. And again, we would have to look at your notice to vacate to see if that's true. And as we said earlier, merely giving you a notice doesn't mean that if you overstay, that the sheriff's at your door. Nothing works that quickly in Maryland. Definitely does not work that quickly in Baltimore City. And it takes a court to order an eviction.
Thanks, Douglas. That was really helpful. And I really appreciate the audience being so engaged and asking all those great questions. And Cindy, why don't you come on back to wrap things up for us?
Yeah, absolutely. Thank you, Megan. And thank you, audiences, for asking so many questions. A lot of times, we don't necessarily know what questions you have. So the only way for us to answer your questions and to provide you those legal information is to interact with us. And again, we're very friendly. So if you do want to talk to an attorney one-on-one, just reach out. So we're at the end of the show, fellow Marylanders out there. Thank you again for watching. So next week we won't be having a show, but the week after that, so February 9th, so the Tuesday after next, we will be back with, for some of you longtime viewers, you might remember Chief Attorney Sunny Desai, who first talked to us about unemployment benefits. So he is going to come back on the show to talk about all the updates, and we do have a lot, all the updates when it comes to unemployment insurance or unemployment benefits. So if you do have a question about unemployment benefits, make sure you're leaving a comment down below, or you can email me, you can email us, you can share this video, you can tell all your friends about it, and if your friends have questions, make sure they send it to us. And that's pretty much it. Thank you so much and have a good rest of the week. We will see you in 2 weeks.